In the marriage of Brooke Woolery versus Harold Woolery Jr., both parties appear. They appear self-represented. They utilized forms that are out there and filed. Let me look here. This is without children, correct?
Yes.
And you have a
Correct.
DRA on file. That helps a lot. And so I'll walk through the DRA with you because I'm really supposed to make an independent finding that things are fair, just, and equitable. And presumably, in my mind, they are if parties are, both on equal playing fields and they both agree on the same thing, then it's usually something I will make the appropriate findings on. But let me walk through this with you. You have submitted a proposed decree, which I appreciate. Brooke, if you are the petitioner, so I'll have you raise your hand. I'm going to swear you in. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Okay, thank you. Please state your name.
Brooke Woolery,
And who are you currently married to?
Harold Woolery,
All right. And when were you married?
August 8th of 2020.
Okay. So this is a 5-year marriage, correct?
Yes.
And there are no children of this marriage or
Correct.
relationship? All right. And you've marked that there is no real estate involved. So
Correct.
neither one of you own a home or owned a home when you got married or anything. Is that
He owns his own home, yes.
okay? Well, this is always a problem because there are forms, but they don't explain to you or train you as an attorney to be able to handle things, but yet you represent yourself, which
Okay.
is fine. I'm okay. I just don't want you to do things that you don't realize you're doing because you didn't get the advice of counsel or the benefit of counsel.
We had a postnuptial agreement about
Okay.
separating things.
Did you
So
file, was it pre or post nuptial?
it was post by like maybe a month or so.
After you got married?
Yeah.
Okay. And that wasn't done? I mean, those can be set aside if there's any evidence of duress or misrepresentation or anything. So are you basically following that post-nup that you signed?
Yes.
Okay. Can you file that or send
Um,
it as an exhibit?
sure.
Okay. That would be helpful
Okay.
because even when people own property in their own name, once you marry, that person has a marital interest in everything that you have.
Okay.
It can be set outside of the marital property, like
Buckle up, guys. Today we're going to witness a divorce hearing that looked simple at first, until the judge uncovered a major issue hiding inside the paperwork. The wife claimed there was no real estate involved, but suddenly it's revealed. The husband owns a fully paid-off house. That instantly changes the entire conversation. The judge begins explaining that even if the home was in his name, marriage can still create legal rights to the property. Now the courtroom shifts from routine paperwork to a serious discussion about ownership, equity, and whether the wife unknowingly signed away valuable rights through a postnuptial agreement.
if you never contributed anything and he wants to make that argument and the court can decide, or if something's inherited or owned pre-marriage, premarital, you can either agree to exclude it or take it in front of the judge and the judge exclude it. But the starting point is everything's marital property and everybody has an interest in each other's property.
Okay.
If you have a prenuptial, that changes the landscape. If you have a valid postnuptial, that also changed the landscape. So if you have a postnuptial that you both believe you're bound by and you believe you're bound by, then you are not, or maybe could not claim an interest in his house anyway. Okay.
Right.
So, but technically, if you live with somebody for 5 years and you help pay for things and you take care of the house and you clean house, I mean, you are entitled in any equity built within that 5-year marriage and you living there, generally speaking.
Okay.
So that's why I brought it up, because there's always a lot of confusion with that. So, sir, is your house paid off or do you have a mortgage?
It is paid for.
Okay. Because I was going to say too, you would want to get off the mortgage. And often, even if you're not claiming any interest, a title company wants a quit claim deed if someone is married during any of the ownership of the property when they go to sell it. Are you following me? So,
Yes.
you still might legally want to do that so that if you go to sell it later and somebody researches it, realizes you were married, and wants to make sure there's a very clear, clean title for the title insurance company, they may have to want to find her and get that. So that's, again, I can't give you legal advice, but I also know you haven't gotten any legal advice. And I'm just suggesting to you that is something that people do in the course of a divorce frequently, with their houses when they're granted their residence or real estate. Okay. All right.
Okay.
So mark that you're both in person. And Brooke, were you a resident of the state of Kansas 60 days prior to filing the divorce?
Yes.
Okay. And yeah, this was filed back on January 16th. So there's a waiting period of 60 days. We're long past that. So we're good there. And are you asking the court to grant this divorce based on incompatibility with
Yes.
irreconcilable differences?
Correct.
Okay. Neither one of you have been or are currently, more importantly, on active duty?
No.
Okay. And did you pay the filing fee when you filed, Brooke?
Yes, I did.
All right. Are you, usually what I do is I usually assess it against the person who filed. And then if the two people get along, he wants to reimburse you for half, great. But I usually don't order repayment because then I have to follow up and enforce that. And I just I think the person that files pays the filing fee. And unless there is, some exception, I just leave it that way. So I'm going to show that they've already been paid by you. Harold, if you want to give her some money to split that cost with her, that's up to you. That would be very nice, but I'm not going to order it. Are you wanting to go back to maiden name, former name, or previous name, Brooke?
My maiden name, yes.
What? Okay.
My maiden name.
Okay. The petitioner's attached order, okay. You've entered into an agreement to separate your property. I'm gonna put the respondent is getting, including the residence. What's the address of the residence?
9275 Southwest Highway 54, Augusta, Kansas.
9075 Southwest Augusta Highway 54, Augusta, Kansas. Now, obviously, that is not a legal description, but I'm going to write the address down. I need to mark this as yes, there is real estate involved. Awarded to respondent. Okay, you're responsible for all debts incurred since separation, which is 12/8 of 25, Brooke, is that correct?
I think 12/18.
Now, the financial reality of this marriage starts coming apart piece by piece. The wife agrees to take responsibility for student loans, car debt, and even payday loans, while also walking away without requesting spousal support. But the judge pauses the hearing to make something very clear. Just because someone agrees to a deal doesn't always mean it's the best deal for them. As the court questions income differences and financial imbalance, the tension quietly builds because it starts sounding like she may have given up far more than most people realize in a 5-year marriage.
When I moved out.
Okay, that's right. I read it wrong, sorry. And then you're going to be responsible for the White Eagle Credit Union loan on the Chevy Traverse, which is in your possession as your vehicle.
Yes.
Okay. And your own student loans?
Yes.
Did you incur any of those during the marriage?
Yes.
Okay, well, again, if you went to see an attorney, not always does the person that takes out the loan is assessed 100% as far as debt is concerned. If any of that money that you got for schooling, you help pay for house expenses or some living expenses or something like that. So it's up to you. Now, was that part of your post-nuptial agreement too, that you would be responsible for your school loans?
Correct. Yes.
Okay. And you didn't agree to that under any kind of duress or anything like that, or felt like
No,
you had
we
to?
both had lawyers through that.
Okay, that's good to know too. All right. And then you have a payday loan and you have 2 payday loans, right?
Yep.
Okay, you're gonna take care of those. Okay. And respondent is granted all rights and title. I don't have the legal description. I wish I did, but because I like it to be in there. But you would have to forward that to me. I do want you to forward, it should have been an attachment when you filed your post-nup. I do need that.
Okay. I think I have it in an email I could send to Amy.
Yeah, that'd be fine. Okay. He's responsible for any liens or anything on the property. He says he doesn't have a mortgage or a promissory note. You are not currently pregnant, correct, Brooke?
Correct.
All right. Now, where do you work, Harold?
I am self-employed.
All right. Do you know how much you made for the year 2025? Have you filed your taxes?
We just submitted those. I do not have that information in front of me.
Okay. You've got these school loans. Did you get a job, Brooke? Do you make decent money?
I work 2 part-time jobs.
Okay. Well, I'm going to be honest with you again. That's something you have to see a lawyer about, spousal support. You might be entitled, a judge, I may give you something short-term, as transition out of the marriage and divorce. I may not give you anything. Maintenance is based on disparity in income, displacement from the workforce, because say you were staying home taking care of kids, or for some reason you were staying at home and not working, so you have a lapse in employment. It also so it can be those things, but it usually is more commonly given in long-term marriages. And I would not say that 5 years is what I would consider necessarily a long-term marriage for purposes of spousal support. the other thing is, did you include that in your post-nup that no one would ask for it?
Right.
Okay. So neither support, no spousal support. Okay. Your name change is Newmayer, Numayer.
Yeah, it's Neumayer.
Neumayer, yes. Okay. So I will grant that. I've signed that. And the only thing left is I want to look at your DRA real quick. Again, what is compiled during a 15 or a 50-year marriage can be different than a 5-year marriage, but the principles are the same. And sometimes the greatest asset that two people have when they divorce is their retirement. And technically that can be something over the period of 5 years that was contributed to, like a 401 or that kind of thing, that can have a marital claim. As part of your post-nup, did you agree not to seek any of each other's savings or retirement or that kind of thing?
I believe so, yes.
Okay. Did you both have attorneys or just one of you have an attorney?
We both had 2 different attorneys.
Okay. All right. Okay. So you have a child from a previous relationship, correct?
Yes.
Okay. But you're not claiming anything as a step parent, like that you should be entitled to visitation or anything like that, correct?
I've asked her about visitation actually. I would love to see Charlotte again, but if they don't want me to, then I guess I don't get to.
Okay. Again, that's something you'd have to talk to an attorney about. I have very few step parent visitation requests, but the law allows for you to petition for that as a step parent. You just have to show some things like that you have a bond.
This is where the hearing suddenly turns emotional. Until now, the conversation was mostly about property and debt. But then the husband reveals something unexpected. He wants to continue seeing the wife's daughter from a previous relationship. The courtroom instantly changes tone. The judge carefully explains step-parent visitation rights and how difficult those cases can become. What makes this moment hit so hard is that you can hear the disappointment in his voice. It's no longer just about ending a marriage anymore. Now it's about losing a child connection he clearly wasn't ready to let go of.
That would be detrimental to the child to not have continuing relationship, that it usually, if the parties don't agree to it, it's just something they do outside of court as they agree to, or if they don't, then it usually has to be a matter determined by the court. But I get a lot more grandparent. It's very similar to grandparent visitation. So it's highly unlikely that you would get 50-50 or even, the time would be much less as a step parent, probably for 5 years, than obviously what a natural parent may be entitled to. But
Sure.
you haven't made a
Understand.
claim. And if you want me to move forward, again, I'm not giving you legal advice whether you would prevail, not prevail. I just feel like a lot of people don't know what's available to them, and then it's too late later because,
Yes, I agree. The whole process is there's no if you don't hire an attorney, you don't know anything. So you're kind of out in the dark with it all.
yeah.
I think they need to have a better way of going through this sort of stuff. But that's just my opinion.
Yeah, well, that's why, judges tend to prefer that there at least be one attorney on board looking at these things, even though they can't represent both, they can only represent one, but a lot of people just
It's
don't want to
expensive,
pay
so
an
it's hard to
attorney.
afford it.
I
So,
know. Okay, so I'm looking at the White Eagle checking and savings. Is that, you each have your own?
Yeah, we never got
Okay.
joint.
Okay. And then you kind of listed your expenses, but if you're not asking for out, the reason we look at comparative expenses is if we're looking at potential spousal support. So I'm not going to spend a lot of time with that. I just wanted to look at your assets and your debts, basically. There's not anything substantial that I see here other than the residence is probably fairly substantial. But if you had attorneys and you've agreed to this previously and you're agreeing to it today, then all right. I don't see anything else of question there based on the DRA. But I am going to ask you both this. Have you both fully disclosed to each other your assets and liabilities, no matter whose name they're in or how they were acquired? Do you think each one fully knows what is out there? You haven't hid anything from one another.
Yes.
I believe so, yeah.
Okay. All right. Well, I think you're both, intelligent. You have a previous agreement that you entered into with counsel. This is not a long-term marriage. It was postnuptial, so it's been within the last 5 years that you've talked to counsel. You did enter into a postnuptial agreement, which is enforceable as long as someone's not claiming any kind of fraud or misrepresentation or duress, which hasn't been claimed. You've submitted this by agreement. You haven't both signed it. Mr. Rollery, you did not sign it, but presumably.
At this point, the judge makes one final review of the settlement, making sure both parties fully understand what they're agreeing to. Everything appears settled until the husband quietly admits something that completely changes the emotional weight of the hearing. He says he never wanted the divorce in the first place. That single statement shifts the atmosphere immediately. The judge then explains how no-fault divorce laws work and why one spouse alone can legally end a marriage even if the other person still wants to stay together. It becomes less about legal documents and more about emotional reality.
What we've gone over, you're not objecting to?
Not
Any of it?
not objecting to anything we went over. I did not want to get divorced. I think we could work stuff out. But if she doesn't want to, obviously we're not going to. So
Okay, well, that's a good question, but so basically, for a long, long time, Kansas has been a no-fault state. You don't have to claim a reason to get divorced. Just basically, you don't want to be married anymore, and you base it on incompatibility. And judges really can't deny a request. The only thing I have the authority to do is to order you into counseling before I allow you to get divorced. And that's what the 60-day waiting period is for too, is to make sure people don't quickly, impulsively get divorced and they put some thought into it. And that's why there's a waiting period. So I could not prevent her from getting a divorce. She would get one if she wanted one. The only thing I could do is postpone it and order you into counseling. And I've normally only done that in maybe a time or two because there were children involved. And I really felt like the couple maybe needed more time, but it's not something I do on a regular basis. But I do
Sure.
understand you're not the only one. There are plenty of folks that end up divorced and didn't particularly want to get the divorce, but you've been separated since December. And so I am going to find that you are incompatible with irreconcilable differences. And I'm going to restore Brooke's former or maiden name. I'm going to award you the real estate based on a postnuptial agreement that will be attached. I believe that everything's been divided. And Brooke, do you believe overall this is fair, just, and equitable?
Yes, I do.
All right. And Mr. Woolery, other than you not wanting to be divorced, do you think this is a pretty fair settlement with you getting the house free and clear and no spousal
Yes, ma'am.
support and all of that? All right. So I'm going to find that the division and the submitted decree is fair, just, and equitable, that I have jurisdiction of the parties in the subject matter, that 60 days has elapsed since the filing, which is the waiting period. I will grant and declare a decree of divorce. And once I get that additional document, we will file it. And then there's a 30-day waiting period before you have the capacity to marry anyone else. That is a time period for people to file an appeal if they change their mind or they want to file an appeal for some reason. Generally, that's not something you can do before the Court of Appeals by yourself. To go in front of Court of Appeals or Supreme Court, you usually need representation for an appeal. But I'm supposed to advise you of that. I'm also supposed to advise you that technically you're not legally divorced till this is on file. So even though I granted it today, it becomes official the day it gets filed with the clerk and it's date stamped and court stamped. Okay?
Yep.
All right. Do you have any questions? I assume you've already divided all your personal property because nobody's asking for anything.
Yeah.
Correct.
Okay. All right. Very good then. Well, I wish you both well. Thank you for appearing. It does help when everybody shows up.
Final section is where the marriage officially comes to an end. The judge approves the divorce, awards the property, restores the wife's maiden name, and explains the final legal deadlines before everything becomes official. But even with all the paperwork completed, there's still a heavy feeling left in the courtroom because the husband already admitted he didn't want any of this to happen. What started as a calm, uncontested divorce slowly revealed emotional attachment, financial sacrifice, and the harsh reality that sometimes one person is ready to move on while the other is still holding on. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.